In the interest of fairness and equity in the legal space, sometimes there is the requirement for the status quo to be maintained. This is where injunctions come in. Today, we take on this topic. Thanks for tuning in. This is Law Express. Don't go away. We'll be right back after this commercial break for you to meet my co-panelists, and then we take on the topic, injunctions.
Rindolph Chumesi Ankara is a private legal practitioner who enjoys hanging out with friends, reading, gardening, playing video games, and watching football. Ivan Mensah Dazi is a private legal practitioner whose interests extend beyond the legal sphere. Apart from his professional work, he finds joy in watching and playing football, engaging in community service, spending quality time with friends, and staying informed about current affairs. Nuala Seidu. She's a private legal practitioner and a consistent member of our 3-lawyer panel on the show every week. She also doubles as the host of the show. She likes to play tennis and read.
This is a very interesting topic, especially given the recent developments within our political space. And so you wonder from where we sit, how people actually understand the topic of injunction. And I think it is important that we all get to know what it means, when it can be applied for, the requirements one needs to satisfy the court before it can be granted. I understand it from where I sit because of my profession.
You are a lawyer.
Yes.
But it's a technical area.
It is a very technical area, and you see a lot of people saying all sort of things about it, and sometimes murdering the term for what it means.
Okay. So in simple terms.
In simple terms.
If somebody were to walk up to you on the streets to ask, Papa lawyer, like they always say,
in simple terms, yes. And it is something we get a lot because people would call you and all they want is injunction. But generally, injunction does not actually survive on its own. It has to actually be dependent on something. And so until you have built something, you can put an injunction on.
Yeah.
And so injunction is normally applied for in court when you have a case in court, a substantive matter, a civil matter against somebody. It is not something you can get in a criminal matter. That is where it is between you and the state.
Yeah.
And so when you have a matter in court and you believe that if I delay, by the time this matter is done, perhaps I would have nothing at all to even fight for, then it is a good opportunity for you to ask for interlocutory injunction. Okay. It is just one aspect of what injunction means. Of course, generally, when you are done and a right is actually established and the court says that you are the winner or the court has granted you your relief, then the court may also consider granting you a perpetual injunction, a permanent injunction.
He's tried to summarize the entire injunction conversation, but we need to unpack it. So essentially, injunctions are orders that restrain you from doing something.
Yes.
And so I'm sure Mr. Ankara wants to come in now.
Let me just take it out from where my learned friend left it. So when we talk about injunctions, essentially we are talking about an order emanating or coming from the court, which either restrains a person from going on with doing a thing, or compels a person to do a thing. So more often than not in our conversations, we forget that injunction can be compelling as well.
Yeah.
It can compel you to do something. So the essence, the question will be whether it is even necessary in the course of legal proceedings.
Or it could stop you from even starting.
Yes, from starting. That's to restrain. Because in all cases, the focus is to ensure that whilst a case or a matter is pending in court, the subject matter of the litigation or the subject matter of the suit is not disturbed or is kept in the state in which it was before the suit commenced. So the whole purpose of injunction, or what makes injunctions necessary, is to preserve what the lawyers call status quo, is to keep the subject matter of the litigation in the same condition or state prior to the commencement of the suit.
Or to keep the parties in the same situation or position
as they were before the suit was commenced. So that is essentially why injunctions in themselves are necessary for the preservation of whatever is before the court.
You can't avoid that.
Yeah, I don't want to sound too legalistic, so I'm just trying to the subject matter of the litigation to preserve it. Now, when you in our dispensation, our judicial processes, you can obtain injunction by two means, either on notice to a party or through an ex parte application without notifying the other party. The conditions for either getting an ex parte application injunction or an injunction or notice are very different.
Okay. Basically, an ex parte application, for the benefit of our viewers, is where one party involved in a suit comes to the court to apply for something, some order or some relief, without notifying the other parties involved. By reason of agency and any other thing that might make it important to do so.
I would illustrate it with an example. For instance, most cases where there is a funeral to be held and there is an urgent need for some matters to be resolved before the burial can take place, you run the risk of not being able to serve the person before they bury the body. And so most cases you go ex parte, because if you're going to waste time to look for the people involved to serve them, by the time it's done, they would have buried the body. And so in most cases, it is important that under the circumstance, because of the urgency of the situation, you go to court without notice and tell the court that I am here because of this reason. It is urgent. If I have to waste one more day or 2 more hours to serve them, the action I am seeking to prevent would have already taken place. But the special condition is that once you are able to satisfy all these things, the court is not going to give it to you in perpetuity. The court would only give it to you by the laws regulating our practices. It's only going to last for 10 days.
So you're looking at an interim
injunction.
Interim injunction. So that's he's just explained that you interim injunctions, you can go ex parte for them. And then when you eventually get it, it's for a short period of time. And if you want an extension, you need to reapply to the court. Justify same, or you now go for an interlocutory.
So just to give a bit of a further explanation on why ex parte injunctions are granted for a short period of time, this 10 days. Because you see, our legal system operates on hearing both sides. So in all matters, you must listen to the other party. But because of the emergency situation, the urgency of a particular set of facts, you believe that you cannot, if you wait for the other party, because ordinarily, when you issue a writ, you file a motion for injunction, you have to wait for the other person to be served. They have a time frame within which they'll file their response. You go to court, a date may be fixed for you to come in, for the application to be moved. If you say you're going to wait for that to bid that time, whatever it is you are seeking to restrain the person from doing may have either become moot by the time the application is heard. So the urgency of the time permits you to go for the application without going through all the processes of giving notice.
We can tie that to what he was saying about the funerals.
That is so.
I mean, they're about to bury the person. You know that after the burial, whatever that was to be done before would not be done. So in order not to lose the opportunity, you can opt for that.
So in that case, the law would allow you to get the application without necessarily hearing the other side. But because the other side has not been heard on the substance of the application, it is only going to be for 10 days, after which the law requires that they either come for extension by putting you on notice, so that your side will also be heard. Then the court can give an injunction from the expiration of the 10 days till the final judgment is given.
Let's flip the coin. So you've gone for an interim injunction, which we have established is an emergency injunction. Which you apply for by virtue of constraints of time and agency in all. What about the person that has been injuncted? yes, it's only 10 days, but they have the option to also set it aside.
Exactly, yes.
So
The
if
law-
you
the
still
law-
want to bury
Exactly.
and you are able to mind it,
Yes.
you can apply to have it set aside
Exactly.
with
With-
proper reasons.
Yes, and it has to be within the 10 days, because after
Yes.
10 days, automatically the order will lapse, and that's
Yes.
by operation of law.
Yes.
So if you are served with the order, the injunction order which was obtained without notice to
Yes.
you, then you have within the 10-day period to either apply to set it aside, and you have to state
But
your
do
grounds.
people in practice really do that? Because by the time they serve you, by the time
You
you
have
draft,
just about 3 days left.
Just last year.
And that's
I
if it's
believe
fixed.
One happened just last year.
Okay.
I think the latter part of last year, during the celebration of the Homowo,
okay,
the GA issue, one party obtained an interim injunction against the holding of the event.
okay,
And then I think within 3 days or 4, the
other
former
one
Attorney
set it
General,
Ayikwe
went
Okay.
to court to set it aside, to pave way for them to continue with the process.
yeah.
And so it is possible. But you
Yeah,
need
it
to
is. But the
act,
question is, I'm
yes.
looking at the practical. I mean, how often do people set these aside?
Of course, in the cultural context, as in the case of the Hobo, I think that it will be important because they deal with dates
There was
and
some
specific
public interest.
events.
And more so,
Yes.
it all depends on the agency on both sides.
Yeah.
So if, for instance, 10 days would be too long a time to wait, and you have been served or you have notice of, I mean, you don't necessarily even have to be served with the notice, the order. Once you get notice of the fact that injunction has been granted ex parte, as a lawyer, you can conduct your necessary searches.
Yes.
If it comes out that indeed you can apply, if it is very
I
urgent
think it's
to do
also
so.
a function of social media because lately litigants have this habit of posting their
their
proceedings,
orders on-
especially where there are a lot of people involved. Homowo is a big
Yes.
community event,
Yes.
okay? And if you intend to injunct them, whoever is applying is likely to even say, I've applied,
Yeah.
or post processes online.
Yes.
So it gives the lawyers on the other side ample time to prepare, to set it aside, or to oppose if they are minded to.
But
Yes.
you see, in their case, it was the issue about publication
Yeah.
and the dates, the preparations that had gone into it. So I believe, if my memory serves me right, they set it aside on Thursday, and on Friday the event
The
began.
event happened. There was no
You
time
understand?
to
There was
go
no
back.
time for the other party
To go back
now
again.
go back and say that I am putting them on notice.
Yeah.
And so court is going to entertain that.
It's
And
all
I
part-
believe
it's
that the
strategic.
court was minded also to set aside the interim injunction because of all these issues. They had expended money, they had made a lot of preparations, they had invited a lot of people from even outside the country, and some of them had come. And so they believe that, yes, given the special circumstances, it was okay that
I do
they
not think
functioned
those are
with
probably fully the parameters under which injunctions are
Yes, so-
granted. But I mean,
Yes.
that is also, it could weigh in on the
That's what I was
conversation.
coming to add on to.
But probably that is a good point to now introduce an interlocutory injunction.
Yes, so
So we can talk about what you need to convince the court with in order to get an injunction generally.
So like my colleague, when he started his submission, made a point that there are some clients that come to you and the first thing they say is, lawyer,
I want an
let
injunction.
me just quit, make an injunction. I want an injunction right now. Forgetting that before the injunction, you must actually commence a suit.
Yes.
There should be a substantive matter before the court. Now, if you look at our laws, before you can get an interlocutory injunction granted to you, there is a condition or a standard that must be met, which is that the balance of convenience should weigh in your favor. So a judge seated to determine an application for interlocutory injunction pending the final determination of a suit would have to weigh the scales. Okay, when I listen to you and I listen to this person, whose side would be more inconvenient? Who would be more inconvenienced
Who
if I grant
suffer
it?
more.
Inconvenience
Yeah.
when I grant the application. And who is likely not to lose anything?
Yeah.
So the court looks at it and says, okay, based on these facts, I mean, I don't think you, the applicant, you suffer any inconvenience or hardship. So let me just
So,
not refuse the application.
Yeah.
So it's not automatic that once you file an application, it will be granted. And that's why in recent time we've had so many debates about when you have notice of an injunction, blah, 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 and all of that. But I'm sure we'll get there.
We will get there, but now that we've introduced an interlocutory, I think we need to explain it as well, just so our viewers can come along with us. Sometimes when lawyers said, we just get carried away. Interlocutory injunctions, like he said, must be premised on a pre-existing action before the court. And that could be a suit by writ. It could be by an originating motion, which is another complication I shouldn't have introduced to this discussion. But basically, there should be a matter that has to be determined by the court, at the end of the day. Then in order for you, like we earlier on introduced, to maintain everybody's situation or position, such that at the end of the day, maybe let's say there's a land matter, and somebody is busy trying to develop it. You know that if there's no injunction granted, at the end of the day, the other person would now have a property on it, and there won't be a bare land they are litigating. The positions have changed. Somebody will now lose more at that point. So to balance it, so you stay at the place you were at the time of the suit, you now apply for an injunction. So where it is an interlocutory injunction, it lasts for the period that the suit, the main matter, is to be adjudicated on. So the day judgment is given, that interlocutory injunction terminates.
Now we go into the realms of perpetual injunction.
Perfect. Then you go to perpetual injunctions. Do you want to explain that now? So when we hit it, we don't need to go back to this.
So I mean, perpetual, I believe, is stems from the English word in perpetuity. So
forever.
Forever.
It's
a permanent order, which is given after the court has listened to all the parties, taken all the evidence that needs to be taken, weighed the evidence, evaluated it, and come to a conclusion that this person's case is more convincing than that of this person. So I am granting the reliefs that Ivan has asked the court for. And in addition, because I don't want you and your descendants to come and disturb him or his descendants, we are granting an order forever, restraining you
stay away from
to stay away from disturbing him with regard to the subject matter. That's it. So that is when we say perpetual injunction, essentially.
And those are normally grounded in the originating process.
That is
and so if you, the documents you filed to start the process.
Yes, it has to be there.
I said this because when we were explaining the interim and in the interlocutory, we talked about the fact that they are temporary. So probably probably later in the conversation, we would rehash the three forms or types.
I think that the most difficult sometimes would be the interlocutory, in the sense that it appears to be the point where parties are agitated, angry, fighting, and one party is actually continuing with some conduct the other party feels offended by, and if the other party should wait till the matter is determined, if he believes that he would have lost already. And of course, in the eye of the public, I mean, once a matter is in court and the person continues to do the very thing I want a decision against, of course, then I'm losing.
It's a moral victory.
Of course. And so that is where the issue is. And it is not automatic. It is not something that you get out of right.
So saying that, let's now talk about what you need to prove.
Yes.
First of all, who would apply for an injunction in a suit?
Well,
then what do you need to prove?
Either party can apply for interlocutory injunction. The defendant or the plaintiff. Anybody at all who is a party in the matter can apply. But you should be able to establish that indeed you do not have a frivolous case, that the matter you have brought before the court is not something that would amount to nothing at the end of the day.
It has a high likelihood of success.
That there is some serious issues that the court would have to determine. Yes, and having first considered that, the court would also find out whether what you are asking for, you cannot be compensated in monetary terms. In other words, if the court were to allow the other party to continue with the act, at the end of the day, when the matter is determined, would they be able to pay you some money to appease you, sort of, to put you at ease? If that cannot be done, then the court says yes. This is
always something I find a bit interesting. Yes, we all know that an injunction is an equitable relief. I mean, and equity is the sister or the
Yes.
sibling of the law.
Yes.
And they move together. But it's subjective. You might say that if Mr. Chumesi takes your land,
Yes.
you will never get another land like that.
Yes.
But the argument would be that you would probably have still sold that land eventually.
Yeah,
For
but,
money.
But it doesn't
but,
matter.
but
For money.
until you part with your
Yes.
interest in the land, it's your land. And then
Yes.
as the law has always been
I'm
that-
looking at a bit of the compensation, such that monetary compensation won't cut it.
No, it's the understanding from there, I believe, is that, you see, the law has been that no two lands are the same. You can even
Yes.
have adjoining lands that are not the same. So if my land is to the left and I build, my view will be different from your view if you're on the right.
Perfect. But you could get a better view altogether at another location if he compensates
that is
But
you
that is what-
with
determined.
more money.
That is what actually makes the case stronger, that no two lands are the same. Where you are taking me to is not the same as where I have and I want to be.
Yeah.
You are asking me to accept. It's more like you are replacing my land for me. So I am losing this land in lieu of another land that you're going to give to me. So that is even a concession in itself, that the two lands are not the same.
I just had to poke that because this argument is something that normally comes up in land litigation,
Yes.
where there's an application for an injunction.
And in addition, it would feel more like the court is the one compelling you to sell your land to somebody.
Yes.
But you have the right to decide who you sell your property to.
And when?
And when. Yes.
Exactly.
There are also other things that heirlooms, family heirlooms, family property, legacies. We're just making it look like it's just about land. But
No,
it could
there-
be
there-
about other things that
Injunction
you
can
have
be in respect of
serious
anything at
sentimental
all.
value. It could even be about holding yourself out as family head
Yes.
Yeah, of course.
and taking some decisions that could
Yeah.
affect people's lives.
Yeah, of course.
We're going to continue from here, okay? But let's go for a quick commercial break. Don't go away. This is Law Express. We'll be right back.
Learned friend, my friend, also mentioned two of the elements that you need to satisfy to get an order for interlocutory injunction. And I want to add that there's also another leg of it, which is that you would have to, the applicant, that's the one who has made the application to the court, that I want you to injunct or to give me an
To
injunction
restrain
against
this
Luella
person.
or Ivan,
Yeah.
would have to show that with regard to the subject matter in dispute, you either have a right in law or in equity. If I'm disputing with you over your car, which all documentation show is in your name,
Yes.
everything shows that it's in your name. I have never even met you before. I don't even know where you are from. I know next to nothing about you. And you issue a writ and you ask the court that restrain her from driving the car. The court will now want to find out
What
what
rights
is your
do you
interest,
have?
what
Yeah.
right do you have in the car for you to ask the court to stop Noella from driving the car while the matter is pending. So this is a legitimate question that the court will even first interrogate before it goes on to
I
see whether
think
it will
this
be just
is
or otherwise.
what has helped with litigations involving chieftaincy, where they are likely the courts the court or the House of Chiefs
Yes.
is
The
likely
judicial
to say
committees,
yes,
yes.
is likely to say that allow the person to perform his or
right.
her duties, okay,
Yes.
pending the determination of the
right,
case.
yes.
Mostly because it's a community interest here.
Yes.
And if they injunct a chief from acting because of just you, what about the hundreds or thousands of other people who could benefit from that office and by his actions?
And also, just to add to what you have said, I think that in relation to those institutions and maybe other statutory bodies, there is a presumption. The courts probably operate on the presumption that there is a regularity to whatever the person has been appointed to do. It's regular until it has been set aside.
Yeah.
So until we set it aside, let's not disturb
The
what
status
is there
quo again.
until we come to that
Yeah.
conclusion that what was done was not regular. I think that is the reason why maybe the institutions, with regards to those bodies, chieftaincy and other statutory bodies, the courts are slow to restrain the occupant of the office from performing the functions of the
So
office.
you've explained the point on the balance of convenience. Yes, so the court is weighing on the scales to
Yes.
see
Who
who
will be
is
much more
likely to
affected.
lose the most
Yes.
and what can we do to hold or preserve the status quo until the matter is finalized. You've now proved all of this. That
Yes.
is not all, right?
Yes. You are now in the mercy of the judge. Essentially.
Yes.
The judge now has to use his own discretion to say that what you have proved indeed weighs up to the standard, and that I'm going to give you the blessing.
This is where the judge plays God.
Exactly. And I mean, the discretion, there are no precedents to exercise of discretion.
But there's the requirement of
There
reasonableness.
is a requirement under the Constitution, but of course, in terms of how it is expressed,
But
you and I
see,
do not
this
have
is
it.
a judicial rule,
Yes.
and we know. I mean, you cannot come and grant an injunction in a situation where it's absurd.
Obviously,
I mean,
yes.
at the end of the day, the judge is still a human being.
Yes.
So let's not make it look like that discretion has no grounding or no fencing.
Yes.
You need to still operate within some parameters.
Absolutely.
Yeah.
Absolutely. But ultimately, the decision lies with the judge.
Because it is exercise of his or her discretion.
Yes.
Except that in the exercise of that discretion, he's
Perfect.
bound by
Certain
parameters.
Yes.
So when he decides that, okay, I have considered all these things and this is my decision.
I like to remind always
Yes.
the court that, look, there are still parameters within which this discretion should be exercised.
Of course, yes.
And of course, there's an option if you feel that that injunction or the ruling in that particular application was absurd, you can go higher.
yes,
Yes.
You can opt
And
to
yeah.
have it quashed, or you
Yes.
can opt to appeal it.
And in
Yes.
fact, just to add, going up to appeal or challenge a decision based on discretion, I think is one of the most difficult things
Yeah.
to do as well. Because then you are now supposed to demonstrate to the appellate court that the judge did not act fairly, based on the facts.
But you still can
Because
have
you're questioning
room.
his discretion
Like
or
I
her
said,
discretion.
because of the issue of discretion, there's so much room to operate.
yes.
So by the time you raise your hand to say that the judge has operated in a very absurd or wrong manner,
Yeah.
it means that there will be a lot of evidence to support.
Exactly.
Yeah.
Yes.
So that is what you rely on.
yes.
Because, yeah, the law is there, the judge has parameters to operate within,
Yes.
but there will always be a winner and loser in every situation.
I believe that each case would have to be looked at,
On its own.
yes, on its own merits. For instance,
and special circumstances.
exactly. For
also.
instance, if a tenant who is under serious pressure to quit comes for injunction to protect his interest, and the judge says that no, I have weighed the balance, and I don't think that you are entitled to anything. Okay, of course, on the face of it, you would ask why. What exactly would be? Because if you weigh the balance of
Yeah.
convenience, obviously it will be in favor of
Of
the tenant. So
yes.
what other circumstances?
As a weaker party.
Exactly. What other situations are in consideration here for him not to be entitled to the injunction?
injunction.
That is where the difficulty would be.
Great. We sampled people's opinion on the streets of Accra. Let's take a listen,
You did
and
all
then
that?
we can respond to that. Yes, we do.
Injunction is it's a court order given to a person to stop a specific something or the going ahead of it. That is what I understand by injunction.
Injunction is an order given to a person from court to refrain the person from doing something.
So injunction to me is an illegal statement or a decree from the court which prevents an individual or an organization from doing one thing or the other.
I mean, from listening to the sampled views from the public, you notice clearly that their understanding of what an injunction is not very far removed from what we have said.
Yeah.
I mean, each of them comes to the point that it's an order from court restraining you. So from what they have said, all of them
Have
assume
an
that it has to
idea.
be,
Yes.
they have an idea, and from their views, it has to be an order. But sometimes injunction doesn't necessarily, injuncting you from doing a thing doesn't necessarily have to be a specific order. And I'm sure they've all listened to this back and forth debate
Yeah.
as to if you are served with an injunction, you have to. So sometimes just service of the notice for the injunction on you by law is supposed to hold you back or restrain you from doing certain acts. But I'm sure with time we will delve into that area. So But I mean,
This is a very technical area because there is also the contention as to whether in the performance of constitutional duties an injunction can lie.
Yeah.
I mean, this is one that is actually coming up.
So we are looking at injunctions with state actors and against the state. But I think that should be a whole conversation for another day. Let's try to do the simplified version of what injunctions are. And it's good that he talked about the implications of, for instance, the application itself being pending. So here's the case: the party has applied to court. The court hasn't heard it yet. What is the impact on the one that is going to be injuncted, or they are seeking to injunct? Then after that, we will have to explore situations where people disobey injunctions as a court order, the consequences. So we can talk about the pending application, the implications on you, how you should behave or conduct yourself.
The court has held that once you are served with the application seeking to restrain you from doing an act, you going ahead to do the act in itself is a violation of the court, because you prevent the court from actually making a decision. You've gone ahead to do an act without giving the court the opportunity to determine whether or not.
So you are
should
jeopardizing the
exactly.
proceedings.
So more you are taking the court's power from it, and you deciding that I'm going to go ahead regardless. There are also some people who think that though the service of application or a motion in itself does not constitute an injunction.
But this is not a regular service. I agree with the courts because, and I say this knowing very well that some lawyers intentionally apply for an injunction. They know they are not likely to succeed, but because they know of the effect, which in itself restrains you from still going ahead with whatever you were doing that they are seeking to restrain you from, they will fix the date or try to get a long date. So if
they'll tell you that they don't fix dates.
They'll tell you they don't fix date, but then the court gives a long date, and then the effects of that application is the same as having been granted that injunction.
It's a legal sabotage.
I think that has been regulated recently because the registrars now will not give you anything more than 2 weeks.
For applications.
Yes, for applications. If you are fortunate, you want to use the court system.
So that's what was fixed. Like that's what has been fixed, or what the courts have sought to fix. And then, but of course, there are new angles to the intervention that has come up now.
So there are instances where the court itself would adjourn to a very long date because perhaps
based on its own convenience.
The court is so inundated with lots of cases and so does not have time. Of course, in this particular, and for me, I believe in the former position that once you are served, you are restrained. And for this reason,
because he doesn't agree, but I agree with you.
A process that actually emanates from the court, for me, carries the authority of the court.
Well, so let's put it in proper perspective, Mr. Ankara, to see if you would still not agree with us. You are.
I'm not alone.
I know.
I have multitudes of court of appeal decisions on my side.
So you have a land under dispute. One party is busy digging. Probably to build a filling station. And you know that would change the very nature of the property, the land.
Digging 24 hours.
Yes, day and night. And normally with these kind of things, they come.
It's actually bad faith.
24 hours of work, construction. You know that at the end of the day, you did not intend to build a filling station, or you do not even plan to do that regardless. So if you allow him to build that, and then you win at the end of the day, how do you restore the land to what it was before to suit your purpose? So you've come for an injunction, and the person has applied. You've been served, and you know that the court now has fixed a date to decide whether or not you can continue with your construction. What if by the time the date comes around, you have finished the construction? It defeats the very purpose of the application.
So I mean, like I said, I don't subscribe to the school of thought that once you are served with a notice of injunction, you have to restrain yourself. In all cases, I don't agree. I think that each case must be considered on its own merits.
Perfect.
So let's say, for instance, the subject matter of the litigation is a perishable item.
Yes.
If you restrain yourself, both of you are going to lose in any way. So why do I have to restrain myself for the item to perish? That's one. 2.
But we're looking at, you see,
So-
don't forget writing on the back of the requirement that it should be something that you cannot be compensated in
Yes,
damages.
yes.
I want to believe that a perishable item can be valued
Yes.
and then you can be paid
Good.
for.
But you also forget the angle about the fact that if there's a sentimental attachment to that item.
If it's already perishable.
perishable.
Good.
What
I mean,
is
it-
the sentiment?
But it could be perishable, but you have sentimental attachment to it, whichever way, and whatever it is you're going to use for.
And
But
your
let me even
sentiments
go
will
to
perish with it.
let me even go to the example that you gave. For instance, is it possible for the court to give an order for the person to reclaim the land? The one who has gone ahead to build, regardless of the penalty.
How
they have
do
paid.
you fix? You see,
No,
land,
because don't forget, even mining
It
companies.
is possible.
Mining companies under our laws
yeah, they're
have the
supposed
obligation to
yes,
reclaim the land.
Yes.
Yeah.
So if you have built
But they
on the
never
land,
stay the same as they were before.
but you see, the person has already started the construction, so the land has already changed its character anyway.
Not necessarily.
Not always.
you yourself-
Sometimes they are just about to start.
Yeah.
I think one of you brought in the example of the chiefs.
Yes.
So if I have been installed as a chief
Yes.
and you have a claim against me, you're challenging my nomination or installment as a chief, right?
But waiting
I'm-
2 weeks does not
coming.
kill you in any way.
So, and I've been served with a notice
Yes.
of injunction, and you're telling me that because of the notice, I should restrain myself from performing the functions of a chief,
But
an
you see,
office that
for
I
a
believe
limited
Isn't that,
period
isn't
of
that what
time.
PECO,
But the truth-
isn't that PECO, what PECO
Yes,
deals
I'm
with?
that's ex parte PECO's position. I mean, like I said, I don't even want us to go into the
Yeah,
legalities of
let's
that.
not.
But you see, if I have been, let's even take for instance the constitution itself that we have it, even cure some of this. Once a person has been elected as president, and you are challenging the election of that person, the constitution says that the person will still be deemed as president, carry out his functions,
That's
and
it.
if whatever he does will stay. Now, so that's
That's why nobody's applying to
that's what I'm
injunct
saying. That is-
anybody
that-
from
I'm saying
acting
that
as
even
president.
in cases where we all agree that at the end of the day, the court can declare your election as void, the law still saves your acts done within that period.
Yes.
So that it will not go with the invalidity, otherwise won't go with.
Yeah.
So back to the point. If there is a power for the court to restore, like you said, one of the instances where injunction will not apply is if the person can be compensated in monetary or other ways, if there
Yeah.
are other options available to you. So if, for instance, the court has power to, let's say I have done a case where I didn't go for an injunction, the person built a house. I didn't apply for an injunction. I
The
didn't
house
already-
is already built.
the
What
house
are you
already, I didn't apply
injuncting
for an injunction. No,
Yeah.
I didn't apply for an injunction. I didn't, my client won. Now he is begging that he wants his house. I said the court said we should recover. So whatever is on the land belongs to us. I deliberately didn't go for injunction.
Yeah.
But I could have asked the court that to order the person to demolish the house and then reclaim the land to its original state, and he would have done it. So for me, just because if I had filed an injunction and served him with it, and he went ahead to build, I wouldn't have even followed up with how do you call it?
But you know what the courts say. I mean, if there's
Yes.
a pending application and you still go ahead, you are in contempt. Then contempt applications are
Yeah,
brought.
the contempt, I think the court looks at it on a case by case, because you remember the Dufour matter, the ex parte Dufour that we all talk about, where the Supreme Court even expanded the scope widely. I think your office did it, if I'm not mistaken. Yes.
This is not the platform.
Yes. Expanded the scope of injunction and said once you're even served with the writ, refrain from doing anything that affects the subject matter. Even in that case itself, the bank went ahead to do exactly what the man was restraining them from doing. And the Supreme Court still found that there was no contempt in that case.
But then it also goes to the issue of
it goes to the
discretion.
classification of
And all
what
of that.
they did, whether
Yeah.
it was administrative or
We've
or
already
That's what I'm saying, so it's on a
established
case by
that
case basis.
not all cases are same.
Yeah.
But then the general rule is that if there's
General,
an
yes.
application for an
Restrain,
injunction,
yeah.
it restrains you
Yes.
until that application is considered.
Yes.
I mean, and like you said, there's an intervention when our applications are given a 2-week turnaround period.
I think that's
2
the Supreme
weeks.
Court, so I don't know about the High Court.
Well, but I mean, it's a general
The High
thing
Court,
going
yeah,
around,
they-
yes.
they do
So,
it, yes.
2 weeks is not too long. But I also mentioned the mischief of people from years ago who would apply. I've done a case where there was an origination process filed, an interlocutory injunction writing on the back, same day also filed. The interlocutory injunction was never moved because there was a permanent injunction in the originating process. So at the end of the day, because of delays back and forth, legal vacation and time ran, it became moot. So at the end of the day, once the permanent injunction was determined, there was no need to even touch the other one.
Yes,
The lawyer decided to waive moving the interlocutory ahead of that.
But you see, that's why I come back to the point that each case must be taken on its own merits.
Yes.
Because, for instance, let's assume that my learned friend here has a certain religious belief. and that the religious belief curtails him from doing maybe blood transfusion among others.
Yes.
Right? And I don't subscribe to that belief. And there is someone of mutual interest to us who needs blood transfusion. And he goes to court and follows up with an injunction to restrain the doctor from going ahead with the transfusion. In that case, it's a matter of life or death. It's either the person gets it or not. So in such a situation, I don't think that we have to wait for 2 weeks, because the 2 weeks in that case will be the longest wait ever.
Listen, I don't think that it will even come up.
I don't even know.
It's actually a live case I'm talking to you about.
Because is there a pre-existing suit? What is your interest? Do you have that power to make that call about the person's health condition? Then we look at the doctor's duty, the hospital's duty to saving lives. It's a potpourri of
so that's what I'm saying.
issues.
And at the end of the day, is the person incapable of making decision for himself?
Oh, so let's add the barrier that the person is in a situation where he's incapable of making that decision, and you are even
trying to make the call.
But the call is against the person's right to life. So now the doctor and the next friend are conflicted, and the next friend has gone to court, filed a motion for injunction. Don't forget, we are dealing with the matter of life.
So it's more like, don't save my relative's life.
And 2
because
weeks,
of
2 weeks may not be enough time, may not be a long time, but 2 weeks in that situation is either going to save or kill somebody.
Well, that's if you've been able to serve the hospital. But we have some questions coming in by way of social media.
So you see why I don't subscribe to the school of thought that once you are saved, you have to...
Let's try to unpack them somehow, because normally there are limitations with these questions.
My name is Abdul, and I run a small business in Accra. A competitor has started using a logo that closely resembles mine, confusing customers. In such a situation, what steps can I take to seek an injunction to stop them from using a similar logo? How long does the process usually take in Ghanaian courts? And what factors do judges consider when deciding whether to grant the injunction? Your insights would be invaluable in helping me protect my business interests.
The question correctly, this person wants to understand the conditions he needs to fulfill. I believe we have already discussed that here.
Yeah.
Yes, and this is an IP situation.
Intellectual property.
Yes.
Sorry,
intellectual property situation, and I think it's one of the special cases we have. I mean, he's entitled to it if indeed he can establish
the requirements.
The requirements we have outlined here.
To the satisfaction
of the court, yes. To the satisfaction.
And then he would have to even demonstrate that he himself has a legal right to the logo.
Yes.
Because just because you are using a logo doesn't mean you have an exclusive right. You have to go through the trademark, all the...
You have to establish that you have registered it, and indeed you are protected under the law.
So once you've not registered it, you cannot stop people from using it, no matter how many years you have used it. It's not your exclusive property.
Hello, Law Express team. My name is Sedi, and I'm from Nungwa. I'm a tenant, and my landlord has refused to fix a serious plumbing issue despite several repeated requests. Can I seek an injunction to compel him to make the necessary repairs?
Unless he's ready to be evicted from the property, then I mean, first and foremost, we will have to look at the tenancy agreement that exists between the two of them. Maybe that will tell us whether the landlord has the obligation to fix plumbing, and that's whether the plumbing defect is actually it's from the landlord or not as a result of his occupation of the property. But whichever be the case, like my learned friend said, if he's able to establish that he has a legal right, he has all the conditions.
I think we're missing out something. He says, can he get an injunction to compel him to...
that would be an order to compel him
but
to do it.
There is a primary office set up for to resolve tenancy issues, and that would be the rent control.
So see a rent magistrate.
See a rent officer to attempt resolving the matter, failing which they can then push it to
the district magistrate,
a rent magistrate to resolve it.
So I think we should just say go to the rent office, rent control, and have a conversation there. And when you are whilst at it, go with your tenancy agreement if you have one, because then it helps to clarify matters.
But it comes with a risk, though. If you want to take on your landlord, then of course you should be prepared for
the property.
Yeah, that doesn't mean you can. No, but it's not always automatic that you will leave the property.
Oh no, I mean, there are 32 requirements for him to even ask you to leave the property.
But he's not challenging his
The ownership.
ownership. He's
No,
just
it's not about
asking
ownership.
that he should,
Oh,
you know, do what he's supposed to do
But you see,
based
I
on
mean,
his understanding.
you may not see that to be a problem because you're a landlord, you understand it's your obligation. But someone will see it as you fighting me, you're a landlord.
Over my own property.
I'm Jake, a shareholder in a company at Sunyane, and I suspect that the board is taking actions that could harm the company's interests. Can I seek an injunction to halt these actions pending further investigation or shareholder approval? What legal grounds would I need to demonstrate for the court to consider granting such an injunction? And what are the typical timelines for such cases in our courts?
With regard to the other leg of he being shareholder, I think we will leave it for another discussion. But
Shareholder rights.
shareholder rights and all of that. But I mean, if he wants to, like we have stated already, he can consult a lawyer, start an action if he believes he has a grounds to do so, start an action, apply for an injunction if there's a legitimate basis to do so, and the court to decide based on the facts whether he should be granted or otherwise.
Well, under the Companies Act, he can have that if he satisfies the court.
Yeah, the conditions.
Yes.
Yes.
But then this is an application or proceedings emanating out of your interests as a shareholder.
exactly.
So that is a more complicated
It's a very
area.
complicated matter.
And yeah, if he's a shareholder, I'm sure he can
Yes.
afford a lawyer.
Depending on the nature of the company.
Yes.
Well,
and if
well,
he's not even a director,
legal-
because the company is run by directors, they make the decisions.
But you know, shareholder rights still matter.
From his question, it doesn't look like he's a director
He's
because
not
he
a
says he's a shareholder.
Yes,
and
but
he
sh- but
suspects
shareholders-
the directors are taking certain decisions.
Great, but shareholders have rights, and
They
so
do,
he can
yes.
step up
They
and
do.
talk to a lawyer.
Yes.
They would unpack it, and then
Or
that's
he
it.
can exercise his right as shareholder and remove all of them as directors.
I think that
And
is,
appoint new
that
directors.
is that is another issue we need to educate people on. That as much as we may attempt on such programs to answer questions and all
We
that,
don't get what
We are
he says.
limited.
we are not actually providing proper legal advice.
I mean, you can't give
And-
any advice based on 3 lines.
Exactly.
you know.
And so to properly address your issue, you need to consult a lawyer.
Consult a lawyer
Absolutely.
in
Yes.
Sunyane. I'm sure
A
they'll advise
lawyer
you.
near you.
Okay, so briefly, about 90% of contempt cases in courts emanates from breach of
Disobeying injunction
orders
applications or
relating to
Yeah.
injunction
Orders,
and orders and
applications,
applications
yeah.
and all that. And so the consequences are a bit harsh because it is more like you disrespecting the court, the authority of the court, disregarding the court's orders and all that. And so if you are found guilty, knowingly to have violated an order of the court,
Yeah.
you could actually be put in prison. Just 2 days
Or
ago,
fined.
we were discussing one.
Or both.
Yes, we were discussing one case where the judge actually sent the the person who committed the contempt, who
Yeah.
disobeyed the court order, to 1 month in prison.
Whoa.
Yes, 1 month.
In a civil matter.
In a civil matter.
Ouch.
Yes, and it depends on how flagrant the disobedience is.
Yeah.
You understand? There are people who actually decide that for me,
I don't care.
I don't care. I will do what I'm supposed to do. There are people who are doing all that.
Yeah.
And so if you deliberately disobey a court order in the form of an injunction, you are in trouble.
Yeah.
You-
Challenging the court
Exactly.
authority or
Yes.
pulling the carpet under the feet of the
Yes.
court is a big deal.
It's a big
Because
deal.
the court does not make orders in a vacuum.
It's a big deal. It's a
Not,
big
nothing
deal.
Britain filming.
Exactly.
And
So
also-
based on that, the court seeks to preserve its powers and its
Yes.
sanctity.
Yes.
not even, just to add to what you have said, not necessarily even to preserve the court itself, but the judiciary is the institution that determines rights of parties. And
Yeah.
then by our laws, final judicial power is with the judiciary. So any act of a person which attempts to constitute a person into a judge or the judiciary is frowned upon. And then also we have, as part of respecting institutions, especially the judiciary, we are all admonished to refrain from acts or deeds that may remotely or otherwise be considered as challenging the authority of the courts, not necessarily the courts. That is why anytime an application for injunction or an order for injunction is served on you, you are admonished to stay away from doing anything that can put you in the clause of contempt.
Yeah.
Because once you take a step that runs counter to what the terms of the application or the order is, then you are putting yourself in the position of either spending your Easter vacation, Christmas or otherwise in jail.
Weekends,
Yeah.
yes.
Or your weekends in jail. Or you'll be asked to compensate or pay some cost that you may not even have the money to afford based on your conduct. So it's important that we refrain or restrain ourselves from doing things that would saddle us with the effects of
It's also
And
because
and in
failing to
all
comply with
instances,
injunctions.
even where you are fined,
Yeah.
there is the additional
of a
statement that if you fail to pay,
you go to jail.
you go to jail.
I mean, it's to stop people from acting wrongly, and also to offer them or push them out or put them out there as an example for others
Yes.
to learn, and also to deter
Yes.
everybody else,
Yes.
so we can have order in our
Yes,
system.
and to
Yeah.
promote respect for the
Yeah.
courts and institutions.
Yeah.
And I believe those who have been around from 2013 thereabout, they've seen cases where the court openly have sentenced people
Yeah.
for contempt.
Not just people, prominent
Prominent,
who were prominent in society.
people. And so even if prominent people are being cited for contempt and being jailed, then you can imagine what the court will do to
I think Sir John of
you.
There's
blessed memory.
equality.
Yes.
There's equality before the
course.
law, so it doesn't matter if you're prominent
Presumably.
or not.
We'll have that
Presumably.
discussion offset.
Yes.
Very well. Injunction orders, like all others, are there to preserve the status quo and to maintain and restore law and order. On today's episode, I was joined by Randolph Chimesiankra and Ivan Mensah Dadsi. Thank you, gentlemen, for being my co-panelists. My name is Nuala Seidu. You've been watching Law Express. Thanks for tuning in. Till same time next week. Goodbye.